Baby. I live in Hooksett, New Hampshire. I am strongly in support of this bill. In fact, I take a bit of credit for its introduction. I asked a lot of state reps for the last few years to propose this. As you probably know, no firearms or anything are illegal in New Hampshire. No weapons, no items really are legal. Brass knuckles and the others in this bill are the last vestige of criminalized possession of weapons in New Hampshire. So, as you know, I can walk around with an AR-15, open carrying, concealed carrying, which is how it should be. It should be legal, but I can't carry brass knuckles. I want to address the bill from two different perspectives. The first is of natural rights. As a principled voluntarist, I believe we all, as humans, have natural rights, and there are two at hand. Same with gun control. The first is the natural right to property. As a human being, I have a natural right to own any property I want. I can own property. I don't have a right to hurt people, but I have the right to own any kind of property I want. If that property is a sweatshirt, if it's a car, even though a car can cause damage, it can hurt people. Even if it's a piece of steel and polymer like I have on my hip right now, any kind of property I have a right to own. It's a natural right. Criminalizing the right to own some property because it could be harmful, it's ridiculous. It violates the principles of the property rights, which would make us more like North Korea. Who, you can't own property there. But also, if we were to criminalize everything that could be dangerous or could cause harm to the user or other people, we really have to ban all vehicles that cause right around as many or more deaths than firearms, a lot more than brass knuckles. We'd have to criminalize smoking and cheeseburgers and drugs and almost every substance in the world. As a critical care and flight certified paramedic, advanced level emergency medicine provider with 12 years experience in EMS, I can tell you, yes, the hamburgers, cheeseburgers, cigarettes kill a lot more people than brass knuckles or even firearms. So we should ban all cheeseburgers and cigarettes and alcohol, which cause way more damage. So that's not feasible. The other natural right is self-defense. All humans, all animals, and some plants even have a natural right to self-defense. And we should be able to use, as I said, every tool at our disposal for self-defense. Personally, I'm a very big firearms enthusiast, and I train people to carry in self-defense and to shoot basic gun safety. I think it is the best tool, but I think it's great to have options for non-lethal force. For instance, if you want to restrain someone who you don't necessarily want to kill because they are a friend or not a very dangerous person or someone got drunk at a party, shooting is really the last resort. I've never drawn my firearm in 5-6 years carrying, and I hope to never do it. I happen to be a mixed martial artist and a boxer and I've trained in jiu-jitsu, and I would use that, and I would use other tools. I'm not a knife fighter, so I wouldn't really use a knife to fight, but as a boxer, brass knuckles is a phenomenal tool for me to supplement my skills, which is punching, to defend myself. So if I'm out and about and someone attacks my wife and baby and me, if I can't carry brass knuckles, it'll be me shooting, which, as we all know, when police have to shoot, those bullets go places. They go through people, they miss, and they can hit other bystanders, which can be catastrophic. But also it's catastrophic for the person shot, the person doing the shooting, because they end up with $1 million in legal bills and/or prison for a long time. So it's bad for everyone. If we are allowed to use brass knuckles, I will carry them. And if I ever have to defend myself, that's one more option, like pepper spray or taser is one more option. That's far less than lethal. And again, I hope to never use it. It's been years. I've never had to use it. I've had patients who are very, very violent, and I've never even had to strike a patient in my life. It's the very last resort. I try to solve everything with words before using force. But this would give us one more great option. That's why I'm a big fan of pepper spray and tasers and everything. I think most tools are really not nearly as effective as firearms, but I think it's great to have options, especially for women, young people, older people who really are at a disadvantage. My mother is 65, 66, and she's arthritic and 5 foot or shrinking and 100 pounds. And if someone attacks her, if she doesn't have a firearm or at least some kind of tool, pepper spray or maybe some tool like this, she doesn't have a prayer at beating up an assailant, let alone 5 assailants. So I see it as helping someone like my wife, who was pregnant for the last 9 months and now a new mother, giving her a tool, and she's also learning boxing. So brass knuckles would be a great tool for her to supplement, and she carries as well a pistol. But this would be a great tool to also have one more tool in the toolbox. Like we see with police, it's proliferating a lot. Police are having mandatory laws to carry tasers and pepper spray, I believe, which is just great tools so they don't have to kill everyone who disagrees with them or presents a potential danger to them. So I think it's great. Lastly, I would say, I don't need my phone anyway. Lastly, I would say this, some people might say it'll increase crime. We'll see brass knuckles used to bash people's heads in because, it can be dangerous and everyone's going to beat each other up and break their skulls 24/7. again, as someone mentioned earlier, criminals don't follow laws. I've written a few books about it now. By definition, criminals, they commit crimes. It's the same root word, obviously. So this wouldn't affect them at all. Those who are going to use weapons or bare hands to commit violent crimes already do so. They already violate the biggest laws. They wouldn't care about this little law making brass knuckles illegal. So this doesn't affect them. This will make us all safer, though, and just allow for way more non-lethal options, which I love because it protects the person, their family, the victim, the attacker, everyone, the bystanders. It protects the legal system from $1 million defensive gun shooting cases that go on for 5-10 years. This would actually improve everyone and save who knows how many millions or billions of dollars in DGU cases. So I'm happy to take questions. Thank you very much.
Thank you, Mr. Axelman. Any questions from the committee? Thank you.
Thank you.
I don't have anyone else signed up to speak. Is there anyone who would wish to speak on this bill? Okay, we'll close the hearing on this bill and be in recess for about 2 minutes. Ready? Okay. Okay, the committee will come out of recess, and is someone here to introduce HB 97? Representative Rose?
Good afternoon again. For the record, I am Representative Jennifer Rhodes. I represent Cheshire District 17, which is Winchester, Richmond, Swansea, Troy, and Fitzwilliam. I am here as the prime sponsor of this bill, also as the vice chairwoman of the Criminal Justice Public Safety Committee. HB 97 is a bill that actually was introduced to us last session as a study committee. And I unfortunately lost a lot of sleep over the way we handled this bill as a study committee. And I took it upon myself to reach out to the New Hampshire Coalition over the summer to correct my wrong and actually make this be a bill instead of a study committee. So the bill that you have in front of you has passed the Criminal Justice Public Safety Committee with a 20-0 vote and was put on the consent calendar and passed out of the House with one big consent vote. HB 97 is not a new law. It is specifically addressing the unlawful and non-consensual violation of someone's privacy for sexual arousal or gratification. The impact of these crimes can be debilitating, demoralizing for the victims, and have long-term emotional and psychological consequences. Victims usually suffer from extreme depression, isolation, unemployment, rising medical costs, all of which are no fault of their own. I'm sorry. What's worse is that these crimes can become extremely dangerous over time if they are not stopped. Even more concerning, these crimes can also be signs of lethal intent if not taken seriously. It is time that we amend the statute to ensure that we are protecting victims against being abused over and over again. With us today is a representative from the coalition, and I believe a district attorney. So I would ask if you have any specific questions on exactly how the bill would be implemented as far as the additional penalty, that you could ask them. Other than that, I'm happy to answer any questions you have.
Thank you, Representative Rhodes. Any questions?
Thank you.
Thank you.
Thank you.
Speaking next, we have Pamela Kalick.
Good afternoon, Madam Chair. Oh, thank you so much. Good afternoon. My name is Pamela Keilig, and I am the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. The coalition is the umbrella organization for our 12 community-based crisis centers who support around 15,000 victims of domestic and sexual violence each year with free and confidential services. I'm here to speak in support of HB 97, legislation that will bring our state's violation of privacy statute, RSA 6449, into alignment with other similar laws relative to sexual violence and exploitation. Thank you so much for the opportunity to speak today. Unfortunately, Merrimack County Attorney Paul Halverson was going to be here to speak in support, and I believe he emailed his testimony to the committee. He had an emergency come up this afternoon and was unable to come in, but is more than happy to answer any questions that come up today. And I do have copies as well if that would be helpful. So I wanted to quickly provide a brief overview of why this legislation is important, and then also speak a little bit about the impact of sexually violent crimes on victims. So RSA 6449 is one of several statutes that seek to address crimes relating to sexual violence and abuse. Both RSA 6451, the lewdness and indecent exposure statute, and RSA 652, relating to obscene material or as obscene matter, already have specific provisions that address cases where offenders commit the same crime again and again. And so revising the violations of privacy statute by adding a similar provision would create alignment and consistency across the board when relating to these specific sex-based crimes and addressing the pattern of behavior that we see. These crimes are committed with the intent for personal sexual gratification and arousal, and often they escalate over time, as you heard the sponsor say. These issues are being directly addressed by this amendment. And I think, just to be clear, when we're talking about violations of privacy, we're talking about acts of someone viewing or videoing someone else without their knowledge or consent in their private home or other location, like a fitting room or just a bathroom, for example. And so I think, especially with advancements in technology, this is a really relevant amendment to the statute. And I also want to point out that violations of privacy can be co-occurring with acts of stalking, sexual assault, domestic violence, and child abuse, with the specific intent of seeking to undermine a victim's safety and control the victim. And so that's why this is of particular interest to the coalition. And I think part of that is recognizing that these crimes can again become lethal over time and evolve over time and lead to physical violence and assault. And they can have lasting impacts on the emotional and physical well-being of a victim. And I think in my testimony, you'll see a handout with some statistics of just the state of sexual violence in New Hampshire, as well as some case studies that we wanted to highlight to just demonstrate what we are seeing in communities across the state. Because research has really shown that there can be a link between voyeuristic behavior and physical violence. And it's really important that we effectively intervene to not only limit the harm that the perpetrator does to the victim, but also ensure that sex offenders receive the interventions needed. So it's kind of looking at it very holistically when we're drafting these policies, and so that we address and stop the cycle of violence and prevent future abuse. But I will wrap up there and just say I really urge you to consider supporting this bill, and I'd be happy to answer any questions.
Thank you. Any questions?
All right.
I have a quick question,
yes.
if you don't mind.
Yeah, of course.
You mentioned that this bill would align this particular offense with other offenses. Can you remind the committee about that?
Yeah, so there are several other, so the lewdness and indecent exposure and obscene material, I keep saying the wrong thing, obscene matter statutes already have a provision that address subsequent offenses. And so this is one that if we're looking holistically at sexually violent crimes, the reason they're there is to address the pattern of behavior that we see, where often these crimes are repeated over and over again. And I have someone here who might be able to speak a bit more about that pattern of behavior. It's really important that right now we're seeing someone will do the same thing over and over again, and it just stays flat. So they get a misdemeanor, and then a few months later, it's the same thing. And so we're looking at really addressing that subsequent offense so that it's in line with that escalated behavior and in line with other statutes that are addressing sexually violent crimes.
Thank you. And if you don't mind taking a follow-up question, so with this alignment, so this is for the second offense, correct?
Yes.
And is that the alignment with other offenses? too,
Yeah,
for the second
I
offense?
believe the exact same language, so second or subsequent offense.
Okay, thank you.
Yeah.
Thank you. You,
Thank you. So with a subsequent offense enhancement to a penalty, it can come up three
Attorney
different.
Lehman, why don't you come ask me and we can touch base rather than asking the witness directly. Thanks.
Thank you very much. Oh, okay.
Thank you, Ms. Kayla.
Okay. And again, County Attorney Halverson would be more than happy to answer some of those questions.
Okay. The last speaker we have is Scott Hampton.
Good afternoon, Madam Chair, members of the committee. My name is Dr. Scott Hampton. I'm the director of an organization called Ending the Violence out in Dover. My background's in clinical psychology, and for the past, 32 years, I've been working directly with thousands of perpetrators of sexual and domestic violence. And it's from that experience that I'll be making my comments today. First, I want to say that I am in support of House Bill 97. And my testimony is going to focus on the deterrent effect of the proposed bill. And to do that, I need to talk a little bit about the forces or influences that have sent the message to offenders that it's okay to violate someone's privacy. So the first thing I need to mention is just a comment about sexual violence. Sexual violence is actually unique in terms of types of violence because it's context dependent. And what I mean by that is if you get shot or stabbed, everyone knows it's a violent attack. But if you talk about, say, sexual intercourse, fondling, or voyeurism, it's only a crime depending on whether or not there was fully informed consent. It's always context dependent. That ambiguity sometimes makes it difficult for us to know whether a crime has been committed. And just as importantly, it also makes it easier for offenders to delude themselves into thinking that they haven't crossed a line when in fact they've caused significant harm. So there's a certain amount of invisibility with sexual crimes. So where do offenders learn that invading someone's privacy is an okay thing to do? Well, the primary source of this, actually, surprisingly enough, comes from sex education. The #1 sex education program in the world highly endorses voyeurism. Right? What it does is it teaches some people as young as 10 years old that it's actually okay not just to look at people when they're in the nude, but actually to watch them engaged in sexual activity. It also shows them that it's okay to strangle, slap, humiliate, degrade people during sexual acts. I know this is coming as a bit of a surprise, and there are no consequences. So they do not see in the sex education program that there's any meaningful objection by the victim, and that there are no legal consequences. What do we call the sex education program? Pornography. The #1 source where offenders learn their craft, right? And so before offenders even have a chance to groom their victims, pornography has groomed offenders into believing that violating someone's privacy is an okay thing to do. Why is this such an important thing, and why is it relevant what we're talking about? Let me just give you one example from one of the men in my sex offender treatment program, as he described his progression through his behavior. He walks down the street one night. It's late at night. He looks over at a house, sees that the shade is up. It's dark outside. Lights on. Bedroom. Woman's getting undressed. He stops on the sidewalk. He watches. Goes on his way. The next time he's out there, instead of standing on the sidewalk, he actually walks halfway into the yard, gets closer to the house. The next time, he walks right up to the window, peering in. The next time, he waits for her to be asleep and actually walks up on the porch. That's how he's describing it. Walks on the porch and just feels what it's like to be that close to her. Next time, he grabs the door handle, doesn't try to open it, but just feels what it's like, what would it be like to open this door. This progresses sequentially, where he eventually picks the lock, goes inside, walks down the hall, goes to the bedroom door, and of course, on the last night, he violently rapes this woman. So what started off as a gateway offense, merely looking through a window, has unabatedly progressed into a violent sexual assault. 20% of voyeurs eventually commit sexual assault or rape. They progress into that. Sexual sadists, very interestingly, their primary thing that really gets them off is not the harm they cause, but it's actually watching the suffering. When they talk about it, they talk about how watching someone's pain and suffering is what really does it for them. So voyeurism sort of leads to this. What we need to realize is that voyeurism is a gateway offense, very much like with a drug abuser, where they start off, they drink coffee, smoke cigarettes, have some pot, whatever, before they progress into cocaine, heroin, and crystal meth. Similarly, sex offenders typically in my program start off with these low contact, low risk, voyeuristic activities, and then just like in the case study, they go through successive approximations until they get to their final outcome, which very well may be a violent attack, sometimes the death of the victim. The offenders that I've worked with have described this gradual escalation. They say, I've had several victims before I ever got caught, hundreds of offenses, and they said, I had no intention of stopping until someone delivered a meaningful consequence to me. So I guess the last thing I'd say about this is that we say, well, wait a minute, isn't there already a consequence? Isn't there already a misdemeanor charge? And now to me, and to I'm sure all of you, a misdemeanor is a big deal, right? I don't want to have a criminal record, thank you very much. They have a different starting point. So why do we think that sometimes defense attorneys say, my client would be more than glad to plead to a misdemeanor? Why? Because it doesn't matter. To them, it doesn't really matter. It doesn't drive home the point the way a felony. So when we switched, for instance, the law on non-fatal strangulation from the Missy Charbonneau case from a misdemeanor up to a felony, That was the point. We realized there was a risk involved in here that we underappreciated. Same thing with the voyeuristic stuff. So often this will lead to, 1 out of 5 cases will lead to a very violent assault. And these guys are not paying attention to the misdemeanor charges we're giving. So I think we have an opportunity here today to send the message, no, this is important. This is a meaningful violation, and it's a significant risk factor for things to come. And I'd be glad to take any questions.
Thank you, Mr. Hampton. Any questions from the committee? No, thank you. Thank you, Mr. Hampton.
Thank you very much.
That was the last speaker I had. Is there anyone else here who wishes to speak? Thank you. We'll close the hearing on HB 97.
Hello, Madam Chair. It's so similar. What was that for the next one? Okay, thank you. We're going to go ahead and open the public hearing on House Bill 201 and recognize the prime sponsor, Representative Sykes. Good afternoon, Representative. Good afternoon.
Good afternoon, Madam Chairwoman. Good afternoon, members of the committee. My name is, for the record, my name is Representative George Sykes, Grafton 14, serving the city of Lebanon. I am the prime sponsor of House Bill 201. I won't take an awful lot of your time, but I did want to point out that, to begin, this bill was introduced as a result of literally weeks and months of work on the part of a broad coalition of citizens groups that come under the heading of New Hampshire Drive Safe. And they represented organizations from churches, ACLU, quite a few different organizations. You will have probably received a written testimony from them, and I call it to your attention. This penalty which is very narrowly defined, this bill has been introduced because the penalty for that narrow definition was changed in 2015. And unfortunately, with that change, there came about some very important unintended consequences of that change, and so we are attempting to rectify some of those unintended consequences. For example, one of the most important points I would like to make is that this bill only changes the penalty for drivers who have never had a driver's license in New Hampshire, and it only changes the penalty for the first time offense only, and it changes it from a misdemeanor back to a violation. This first time offense for never having had your driver's license and driving without a license was a violation only for years and years and years. And what has happened is that, and I alluded to the fact that families were being hurt, what we're seeing and learning about is that economically challenged families are being penalized because perhaps they were not able to get their driver's license immediately after it expired. That happens. Or perhaps they've moved into New Hampshire and they're struggling and they need to go get that driver's license. The 60 days where they're required to get it has come to pass, and they had to wait for that next paycheck. Or I think even more importantly, we have learned in the Transportation Committee in the House that there are in fact families in New Hampshire who, for religious reasons do not get their driver's license, even though they may have gotten them in the past in other states. But some of the requirements that New Hampshire has do not allow them to get their driver's license. Imagine you're a mother, you've driven before, you've had a driver's license in the state, let's say Missouri, and you move here to New Hampshire and you can't get one for religious reasons, and then you have a family crisis and you attempt to help your family, and you are stopped without a driver's license and convicted of a misdemeanor. That misdemeanor has, for families that are generally not in trouble with the law, that's very serious consequences for young people, for families, etc. Because as an example, if you were convicted of a misdemeanor in this state and you apply for a job, you are at this, it would have been that you had to check the box. And that can have serious consequences for a family. It can have serious consequences for students who want to go to get a scholarship or go to college and so on. So I want to bring all of those things to your attention. The other important point that I want to make is that all the penalties that would apply for some other offense, let's say you're driving without a driver's license, I'll go back to that mom, she's speeding. She'll get a speeding ticket and deserve it. But she shouldn't be penalized for not, for other than, she'll get a penalty, she'll get a violation for driving without a license as well. And again, it's only for the first time offense. So I think this is the right thing to do for, I hope you will see that this is the right thing to do for economically challenged families, for people who have, for religious reasons, can't get their driver's license, and so on. And that's all I have to say. I would be happy to entertain questions if you would, if you'd like.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Okay, seeing none, thank you very much.
And thank you very much.
Representative Rhodes, would you like to come up? You said if needed. I don't know if you would like to address us.
I believe Representative Roy would like me to speak on it if that.
Yeah, please come forward.
Thank you, Madam Chairman. For the record, I am Representative Jennifer Rhodes. I am here as the Vice Chairwoman for the Criminal Justice Public Safety Committee. I represent Cheshire, still represent Cheshire 17. HB 201, and it is, as the Vice Chairman of the Criminal Justice Committee, I spoke against this bill on the House floor for the following reasons. It is our understanding that a person obtains a driver's license to demonstrate that they at least have a basic understanding of the law and the rules of the road. What we just heard, at least what I just heard, is that this makes an excuse to not ever have to have a driver's license. We heard in committee that it's very expensive, that people can't afford the cost of the driver's education. My suggestion would be that you address the cost of driver's education, or perhaps that law. I do not believe that making an excuse for somebody that may not know the law is a reason to say that you don't ever have to have a driver's license at all. I did some research before I did my floor speech on this bill to see what countries or what states did not require a driver's license. The answer is none. Now, albeit the United States as a whole does not require a driver's license. However, all 50 sovereign states do. There's not one that does not. To say that a person that has never even bothered to get a driver's license would have the same consequence as somebody that perhaps maybe let their driver's license expire. We've all got busy. I have done that. I have found myself, oh my gosh, my license expired. But I was able to rectify that situation in a reasonable, simple matter of time. My understanding is also that if the problem or excuse is that you're not able to get to the DMV, I do believe that you can renew your driver's license that one time online. So there is that. Pretty much every household I know of does have internet. They also have local libraries. You have your phone. It's able to be done that way. We addressed the issues of insurance. You know, New Hampshire is actually one of the cheaper states to drive in, considering we don't require that you actually have to have insurance to do that. But we did have concerns that if you were in a wreck and you were never insured in the first place, there's a good chance that, I'm sorry, if you did have the insurance, you're not going to be able to get the insurance if you don't even have the license. We heard that if you are here and you don't know our laws yet, that would be a reason why you would not have to have your driver's license. But the same could happen if I never have my driver's license and I hit a family that is immigrating into New Hampshire. I could very well harm them just as much as they could harm me if they don't know the laws. So for all of these reasons, I do understand that Chairman Roy has sent you guys this testimony, but I do have it here. But he and I, as the representatives of the committee, are highly against this bill.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Seeing none, thank you, Representative.
Thank you.
Are there any other members of the public who would like to speak to House Bill 201? Okay, seeing none, close the public hearing. Thank you, Matthew. I think we gotta wait a few minutes. Yeah,
Yeah, a couple ahead.
yep, we'll get a couple of minutes. We have 3 minutes. The committee will be in recess for 3 minutes. The committee will come out of recess, and we're going to open the public hearing on House Bill 307 and recognize one of the sponsors, Representative Smith. Good afternoon, Representative.
Chair, and I find it interesting to look at the members of the committee sitting in front of me and former members on the wall around me, and I see an interesting difference. I just thought I'd leave it to you to figure out what that difference is.
I think it's self-evident.
Yes, it should be self-evident that all people are created equal. Good afternoon. I'm Representative Marjorie Smith in my 13th term of representing Durham. The prime sponsor, Dan McGuire, is at this moment sitting in the House Finance Committee struggling to come up with the budget that will or will not pass the House and naturally come across to you. But as the co-sponsor, it is a pleasure to present this bill to the Senate, since it comes to you not with the usual current 10-10 vote from a divided committee, but with a 20-0 vote from the House Judiciary Committee. This bill returns the attorney's fees provision of the Right to Know law, RSA 91A, to the way it used to be when the law was first enacted. As originally enacted, it provided for the award of attorney's fees to a party who goes to court to obtain withheld government records if the party prevails in the court proceeding. In the 1980s, the law was changed to say that even if a citizen prevails in court, they may not receive attorney's fees unless the court finds that the government body knew or should have known that withholding the information violated the Right to Know law. This bill changes the standard back to what it was, so that a person who prevails in court on his or her request for government information be awarded fees. The committee unanimously felt that making this change will encourage governmental bodies to adopt the view that disclosure rather than non-disclosure of information should be their presumptive position when right to know requests are made. The bill, by the way, also allows attorney fees to be awarded to the public body if it is required to defend against a right to know suit that is frivolous or taken in bad faith, again providing that the public body prevailed. This bill recognizes the responsibilities of each side in this matter and puts fairness and equity first. It comes out of the reality that certainly not in every situation, but in more situations than any one of us should accept, there might appear to be an unwillingness on the part of public bodies to act as thoroughly and completely as they are required to do under state law. We look forward to the Senate supporting this change as we work together to support transparency and responsibility. Thank you.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Representative, I just had a quick question. As you know, legislation was passed last year, and we now have the Office of the Right to Know Advocate.
The Ombudsman.
The Ombudsman, and I was surprised not to find any reference to the Ombudsman here, because one of the reasons why that legislation was passed was to prevent people from going to court, that they didn't have to sue, that they could try to resolve it through the Ombudsman. And as we all know, anybody can sue anybody over anything, and that includes municipalities. But I was surprised to not see some sort of suggestion that folks try to mediate through the office of the Ombudsman rather than going right to court.
I think it's a very good question, Senator Carson. The reality is that, first of all, the Ombudsman's office is very new. We made clear, both houses and in fact the governors made clear that using the ombudsman as an alternative makes a lot of sense in terms of speed, in terms of cost, and it's something that we all are hoping is going to be very successful. But not every case is going to go to the ombudsman. And what our concern is in those cases where people go to court for whatever reason, that in fact, if their complaint was ruled legitimate, they should be entitled to fees. Of course, it happens very rarely. We know that it happens in special education cases, for example, where lawyers' fees can be considered. But this is not an attempt to say this is the way people should go. And it's not an attempt to say to lawyers, well, okay, you should go to court because you might be able to get the fees back. It's just a way to say, if that's the alternative that is taken for whatever reason, that there ought to be fairness and equity.
Thank you. I do have another question. I find it interesting in the second section, section 2, that you allow, the bill allows a municipality to sue an individual for making frivolous complaints or issues. Does this address the issue of when someone keeps filing right to know requests over and over and over again, costing municipalities thousands of dollars to reproduce documents and employee time, and those are considered to be frivolous? Say someone who has appointed themselves to be, I'm going to be the watchdog over the town council or the school board and see how they, they're spending money, when most of that information is readily available because the taxpayers are paying for that. So were there any discussions on that particular section of the bill in the House Judiciary Committee?
In that particular, with reference to that particular section, I truthfully can't remember anything. And of course, I don't even play a lawyer on TV. I don't pay a lawyer, I'm not a lawyer. But I do think that the committee was well aware that there are frivolous cases, there are cases that are brought that shouldn't have been brought. There is what we would call abuse of the system. And we wanted to make clear that we acknowledge that, and people should be held responsible for their actions, whether they are the public or the government.
Thank you very much for answering my questions. Are there any other questions? No?
Thank you very much for your
much.
courtesy.
Okay, let's see. I don't see any other. Okay, the chair will call Jessica King. Good afternoon, Ms. King.
Committee. My name is Jessica King. I'm a senior assistant attorney general. Thank you. Let me start over. Good afternoon, members of the committee. My name is Jessica King. I'm a senior assistant attorney general with the Department of Justice. I'm here at the direction of Attorney General Formella to provide informational testimony about concerns the department has regarding HB 307. In its present form, this bill could present significant impairment to the state and public bodies' ability to accurately and faithfully discharge their obligations under the Right to Know statute. So the general rule in litigation is that each party pays its own attorney's fees. As it stands now, the Right to Know law allows attorney's fees to be assessed against the state if the lawsuit was necessary in order to enforce compliance and the public body knew or should have known that their actions violated the statute. I'd like to also point out that RSA 91A8 penalizes public officials if they act in bad faith with monetary penalties. It also allows the court to enjoin future violations and order that the public body undergo training. Those are already things in the right to know law. The law as it stands now is appropriate because it penalizes the public body when it knows or should have known that their actions violated the statute. This new bill will assess fees in the event that a public body loses a right to know suit. In the abstract, that is a pretty simple bar. If you have no liability, if you just follow the law. However, in reality, the right to know law is not black and white. It's not always clear. And it's not always that simple. I have 4 cases that I'd like to point this committee to. In 2020, the Supreme Court overturned decades of precedent saying that public employees' personnel records used to be the rule that those were categorically exempt. In 2020, the Supreme Court overturned that and said now they're subject to a balancing test. And that was in Union Leader Court v. Town of Salem. In the event that the court overturns decades of precedent, this bill would allow attorney's fees to be assessed against the state, even though the state is following the law as it stands now. In 2021, a similar event happened. The Supreme Court re-examined decades of confidentiality in attorney-client communications. That opinion was withdrawn, but it's another example of how the right to know law is not necessarily black and white. In 2023, very recently, the Supreme Court split on the right to know decision based on the governor's assertion of executive privilege. We have no guidance on that now, and the court is split, so we still don't know the parameters of that law or that aspect of the law. And pending right now at the Supreme Court is a case about police personnel records. But in Superior Court, the judge was asked to assess attorney's fees against the state, but the Superior Court judge clearly said the state had no evidence that it knew or should have known the conduct violated the statute. So all of that to say, this is a constantly evolving and changing area of law. The court is leaning towards a balancing test, which means that the state has to make a judgment call in weighing the privacy interest versus the public interest. And it's not always black and white. There are a lot of factors. The state could withhold in good faith to find out later that the privacy interest is not significant. That's not just privacy interest in personnel records. It could be something like trade secrets with corporations. Often corporations designate their trade secrets, and the state has to decide whether that was an appropriate designation or not. And sometimes it's a close call. So this bill could penalize the state and subject to hefty attorney's fees. And my last point is actually going towards the question of the ombudsman. I believe that office alleviates many of the concerns this bill seeks to address. You can file a complaint with the ombudsman. They can waive that fee. A public agency must respond. The ombudsman can compel production, order attendance of the public agency, issue findings, do everything that court can do in a 91A matter lawsuit. If the order of the ombudsman needs to be enforced by the court can order costs and fees paid by the public body in order for the suit to enforce the order of the ombudsman. So I think that office does address a lot of the concerns here. So in closing, this bill could subject the state to attorney's fees, and that could discourage the state from asserting certain viable right to know exceptions. and subject the state to potentially hefty attorney's fees for making close judgment calls. Attorneys are expensive, and it could subject the state to hefty fees just for making that judgment call. So I urge the committee to consider this bill closely and study it to find the right balance between the public's right to know and the public's body execution of a constantly evolving legal field.
Thank you very much for your testimony this afternoon. Are there any questions? Senator Whitley.
Thank you, Madam Chair. Thank you for taking my question. So you're sort of talking about the courts, the New Hampshire Supreme Court sort of evolving thoughts on this. And wouldn't you think that that would be sort of evidence of a reason for the legislature to step in to settle that issue?
I think in a way, if the legislature would like to step in to clarify the law, I think that might be a way to help the court with this evolving area of law. This bill wouldn't clarify the right to know law. It would just, it's a mechanism to enforce attorney's fees.
Follow up?
But that's not my question about sort of clarifying, because, you know, sometimes it's the legislature's role to clarify, but oftentimes it's the legislature's role to set policy. And so, you know, how I see this bill is the legislature taking a clear policy decision on this, you know, apart from, you know, the consideration or the inner workings of the Supreme Court. Wouldn't you agree?
Yeah, I agree. It is the legislature's role to set policy, and it is why we're not taking a firm stance on oppose. But what we're here to do is inform you of the potential risks that we see in the bill and the potential complications that can come later down the line.
Thank you.
Thank you. Are there any other questions? Seeing none, thank you very much.
Thank you.
Representative McGuire, as the prime sponsor of the bill, would you like to, I saw you just come in, would you like to testify on the bill?
Thank you very much, Madam Chair. For the record, Dan McGuire, I'm from Epsom. I apologize for being late. We just finished our executing of the budget. I just say I support this bill. I'm sure you've heard the arguments, but it just seems right that somebody who goes through all the steps to ask for information, get denied, appeal, go to court, win at court, then they should get their attorney's fees paid, because it serves a public purpose to get these kind of decisions out in the open, and we want communities and others to give information freely. And when people are put through all that, and I'm sure you've heard it's very expensive, they ought to, and they win, they ought to not be out of pocket at the end of the day. So thank you very much.
Thank you, Representative. Are there any questions? No? Seeing none, thank you. Okay, the chair will call Tom Mullins.
Thank you, Madam Chair and members of the committee. I do have written testimony that I'd like to submit into the record as well.
If you could hand it to our aide, Matthew. Oh, that's all right.
And I did ask my office to email them to you. My name's Tom Mullins. I'm the city attorney over in Keene, and I'm here sort of in two capacities. I'm here in my capacity as the city attorney for Keene on behalf of the city council and the residents of the city, but I'm also here in my personal capacity as a citizen and a taxpayer here in the state. Unlike the Attorney General's office, you know, I'm not sort of under any constraint to tell you that we oppose the bill. And the reason we oppose the bill are a number of them, but I think the primary one is it really does impose sort of a strict liability offense on municipalities when they are really trying to act reasonably. I mean, there is this sort of sense out there, unfortunately, that we don't take these requests seriously and we don't try and answer them appropriately. And I think I speak for almost all of the municipalities that I know and deal with, and we deal with a lot of them. That's simply not the case. This is a very difficult statute. It's difficult to interpret. It's difficult to implement. It's not the same statute that existed in the 1970s, or in the 1980s. Frankly, I'm not the same individual that I was in the 1980s. But we still have to work with it and evolve with it. And I just wanted to give you a couple of visuals. This is the statute. I have two versions of it. I have a clean one, and I have one with all of my circles and arrows and underlinings and question marks with respect to it. This is my binder on the state superior courts, to the extent that I have collected the ones that I can find. It also has the Attorney General's memorandum in it. This lives next to my desk. This binder contains the New Hampshire Supreme Court decisions back to the 1960s with respect to interpreting the statute. I have to go through this material regularly to try and advise my city council, the people who are responsible for responding to the right to know requests in an appropriate manner. And it's not that easy. As the Attorney General's office has pointed out, our Supreme Court has been very active, and not improperly so in some cases, but from my perspective, improperly so in some cases, in interpreting and changing the law without the legislature's involvement. That was clear recently when they opened up all of the personnel files and records for public employees in the state. Most individuals in the private sector would think that they have a privacy interest in that. Well, we do have a privacy interest according to the court, but we have to balance that. And what we are discovering is it's supposed to be an objective standard. But I challenge anybody in this room to place an objective basis on whatever their privacy interest is with respect to that. It's very difficult to try and parse through all of that. If we make a good faith mistake under this bill, we will have to pay attorney's fees and costs. That's imposing additional requirements and costs on our taxpayers. We're already spending a fair amount of money trying to go through this bill, and not just the bill, I'm sorry, the statute. And it's important to remember, we don't just get right to know requests from individuals who are seeking transparency or open government. We get right to know requests from people who are data mining, corporations that are data mining. We use taxpayer dollars to provide information, governmental records, back to entities that are going to use that information for profit motives. Our statute doesn't consider that at all. I'd like to leave you with one sort of quick reading from a case we were involved in a couple of years ago. That was tremendously difficult and required a fair amount of time. The Superior Court initially, when it issued its decision, after a lot of back and forth, basically pretty much agreed with the city's position with respect to these numerous requests that we received. And it went up to the Supreme Court, and in a memorandum opinion, the Supreme Court basically reversed a number of the decisions and remanded back to the Superior Court. And here's what the court said, the Supreme Court. Here, the circumstances in this case are unusual, if not unique. Within a short period of time, the city received numerous and expansive requests from the requesters' students, raising complicated issues under the right to know law and requiring careful analysis by the city. Only some of those requests are the subject of this litigation. One request in particular required careful analysis by the city attorney in a notably complex and sensitive area of the right to know law. Accordingly, under the circumstances, we conclude that the city's response time in other matters was not unreasonable. That's the point. It was remanded to the Superior Court. The Superior Court, we worked with the court and the requesters, and we came to a result of that. But under this statute, we would have had to pay attorney's fees in that context and costs. It's not fair to look at municipalities and to assume that we are not doing the right thing. The knew or should have known standard is the right standard, and we would request, frankly, that you oppose this bill. Thank you, and I'm open for any questions.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you for your time.
The chair will call Jim Kennedy.
Good afternoon, Your Honor, members of the committee. My name is Jim Kennedy. I'm the city attorney for the city of Concord, New Hampshire. Not to echo everything that fellow city attorney Tom Mullins has said, but the city administration does oppose this bill for the purposes largely that Tom Mullins has stated and that the attorney general has provided. The right to know law is an incredibly complex statute. Picking up on what Attorney Mullins has said, if you look at the right to know law, and some of us still have the books relative to the RSAs, it's the thickest one that exists in the RSA because there's more litigation under the right to know law and the complexities that exist in that statute, I would dare to say, than most other statutes in the state of New Hampshire. Incredibly complex. Putting this type of amendment in the right to know law, removing the new or should have known standard, puts municipalities at grave risk of disclosing confidential information. There are 225 some odd towns in the state. Not all of those 225 towns have attorneys as smart as Tom Mullins or assistant attorney generals in the state. Those employees in those states have to sift through these requests that come on a day-to-day basis and determine what is and what is not a privacy interest, what is and what is not a financial data, confidential information. These are extraordinarily complex questions and to answer without easy answers. The privacy test set forth by the New Hampshire Supreme Court since 2020 is not easy. You have to, and sometimes it's a guessing game for the municipality, for the state, for the public entity responding to these questions have to employ and determine in their best good faith ability to do so. Removing this standard puts those municipalities at risk of these attorney's fees, which can be extraordinary. And I'll use a few examples. We don't get sued often in the city relative to the right to know law. In fact, I've been the attorney there for 15 years, and I think I've had one right to know law case. We do a tremendous job in responding and being transparent in accordance with the right to know law and actually go far beyond what the right to know law requires for transparency. But we did have one case that was extraordinarily complex and difficult, and that involved a case with the ACLU of New Hampshire and the Concord Monitor relative to what and what is not law enforcement information. The city took the position that the information contained in a certain agreement, a confidential agreement, was not subject to disclosure. This case involved Superior Court litigation that was extensive, complex litigation that ultimately went on, where the Superior Court ruled in favor of the city that the information was not subject to disclosure, and then went to the New Hampshire Supreme Court, where again, briefing, oral argument before the Supreme Court, and ultimately a decision of the Supreme Court affirming the city of Concord and its redactions of the agreement. I would say affirming all but one or two portions of the agreement where a couple of sentences out of this 10 or 20 page agreement were determined that they could be released. And the city ultimately agreed and didn't move for reconsideration on those because in the context of the other redactions that were maintained, we agreed that that information could be released. Now, under that circumstance, where one or two sentences out of a 20 or 30 page agreement are determined to be released, attorney's fees, are they now subject to, is the city now subject to attorney's fees under this proposed legislation? That's remarkable if that's the case. Another example that I just want to bring your attention to is a case involving, and I guess the AG mentioned this, and this was the Seacoast United case relative to whether personnel records are subject to disclosure. Up until 2020, a personnel record request came in. The municipality, the state, the public entity said, no, this is categorically exempt. 2020 happens. The New Hampshire Supreme Court flips this on its head. Now these documents are all subject to disclosure. So municipalities up until 2020 are following a good faith standard of what the law is. 2020 happens, it flips, but now under this proposed legislation, attorney's fees are now awarded. The last example I want to give is the case in 2021 is Colquhoun v. City of Nashua. Attorney Lehman might pronounce am I getting the pronunciation right? Yeah. Colquhoun, thank you. But in that case, there was Colquhoun had requested documents from the city. And ultimately, the Superior Court determined that the city failed to follow the right to know law in responding to the document request. It went up to the significantly, the Supreme Court, or the Superior Court said that the attorney's fees request was denied. And so you have a Superior Court saying, no, the city, you did not meet the knew or should have known standard. The city does not have to pay attorney's fees. The plaintiff appealed to the New Hampshire Supreme Court. The Supreme Court ultimately determined, yes, you have to pay attorney's fees. You should have known that you should have produced these documents. However, what I find interesting about that case is that it was a 3-2 decision. So the Supreme Court determines that the city of Nashua knew or should have known that it should have released the documents. And it comes up with that determination when 3 Supreme Court justices, yes, you should have known. 2 Supreme Court justices said, no, you shouldn't have known. And 1 Superior Court judge says, no, you shouldn't have known. If nothing else, that shows the complexity of the right to know law and whether to issue attorney's fees in these very complex cases. And for that reason, and for the other reasons set forth by the New Hampshire Attorney General and the city of Keene, the city opposes this proposed legislation. Now, answer any questions you may have, Your Honor.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you. The chair will call Jennifer Perez.
Good afternoon. I do have written testimony to submit as well. I do apologize for the room error on there. I put the wrong room number, but it is for you guys.
Thank you. Please continue.
Good afternoon. My name is Jennifer Perez, and I am the Deputy City Attorney for the City of Dover. I'm here today to testify in opposition to the bill. This proposed amendment would award attorney's fees in any case where the court determines that a lawsuit was necessary and rules in favor of the requester. It eliminates current language requiring a finding that the municipality knew or should have known that its conduct violated the standard. But as you've heard today, the right to know law is ambiguous. As was previously discussed, since 2020, the right to know law has been changed dramatically. I won't go into the details again on the Seacoast case that changed internal personnel records and how that's interpreted and the effect that this bill would have had in that case. But I will move on to the City of Dover specifically. The city processes many right-to-know requests, and some of these requests contain thousands of pages and require hundreds of redactions. And in every single one of these requests, the city strives to find the right answer. But as was previously testified, the right to know law is very ambiguous and complex, and the right answer may not always be the most right answer that the court decides. And the city cannot guarantee perfection in this matter. But House Bill 307 would require that the city achieve perfection in every step of its process. The city would be required to perfectly interpret the statute exactly how the judge would understand it and perfectly execute that interpretation. It's just an unachievable standard. I'll give a couple of examples. We get right to know requests for school records. That, of course, is dealing with multiple laws, school privacy laws, the right to know law, balancing everything. It's a very complex area, and it takes a lot of work, a lot of research, and a lot of judgment to decide what gets disclosed, how it gets disclosed, and if there's things that need to be redacted or withheld. One decision that a judge doesn't agree with would result in the city having to pay attorney's fees. Another example, we received a right to know request for certain personal pay records. As was briefly stated, personal records, how that is interpreted and how that is applied to right to know has changed recently. And going through that new change in the law and interpreting it and applying it can result in challenges. And any challenge that a requester succeeds on would result in attorney's fees. I want to talk a little bit about Colquhoun versus Nashua. I think I mispronounced that again. I apologize. The sole issue before the court in this case was the issue of attorney's fees, and the court looked to this statute as it reads today and explained that the statute provides that fees shall be awarded. Shall being the operative word. It makes it a requirement. But there was also the limitation that the city must know or should have known. If the city didn't know or should have known, then attorney's fees wouldn't be awarded. A crucial point to the city's arguments in this case and to the analysis in this case was reasonableness. Reasonableness of the request, reasonableness of the city's search. And as was previously stated, this was not a unanimous decision. And that proves just how challenging and complex the right to know law is and how challenging it is to interpret reasonableness and how reasonableness is a highly context-specific question. The dissent in this case stated, and quote, "Hindsight is not the proper perspective to employ when determining whether the city is liable for attorney's fees." The majority recognized that certain terms weren't defined in the law and held a standard that it has consistently held, that it must construe the term in a manner that would provide the greatest information pursuant to both statutory and constitutional objectives. Previously, the sponsors, the previous sponsor, stated that this bill was presented with the belief that it would force municipalities to have a disclosure over non-disclosure approach. This case shows that that's already the standard. Courts have consistently upheld this standard and have applied this standard to various cases. One thing from the Colquhoun versus Nashua case is not just the complexity, but the fact that the system works as it is written today. Cities that do not have a good faith in disclosure or withholding of disclosure can and will have attorney's fees awarded against them. House Bill 307 does not change anything except that it punishes cities that do operate in good faith and other municipalities and public bodies as well. This will affect cities, towns, the state, counties, all public bodies acting in good faith. One final point that I'd like to make is that New Hampshire looks to the Freedom of Information Act when interpreting the right to know. It's been pretty consistent that we try to mirror that fairly well. This isn't consistent with that. I would urge this council to try and maintain consistency and vote against House Bill 307. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you. Okay, the chair will call Chris Maidman.
Good afternoon. Thank you, Madam Chair, members of the committee. For the record, my name is Chris Maidman. I'm here on behalf of Americans for Prosperity New Hampshire today, and we're here in support of House Bill 307. This bill, as you've heard before, I'll try not to repeat anybody, would send a clear message that the New Hampshire legislature strongly supports government transparency and accountability, and it strongly supports the right of the taxpayer to access documents created by the government on their behalf or acting on their behalf. We believe that sunlight is the best disinfectant, and so when government willfully fails to disclose information that is owed to the taxpayer or the requester, that there should be some penalty for that to make sure that they stay in compliance with the right to know law and the spirit of accountability. This bill, if passed, would strongly signal that the legislature believes in a presumption of disclosure and that records should be released unless there's clear and convincing evidence not to maintain compliance with the law. And I believe that by following that standard, a lot of these lawsuits, the hypothetical lawsuits and hypothetical attorney's fees that were spoken about could be avoided just by the government maintaining that presumption of disclosure in favor of turning that over in a right to know request. A 2015 study by the Center for Public Integrity, I apologize, I couldn't find a more recent one, did grade New Hampshire as an F with public access to information, and that is very troubling for a state that I believe, we pride ourselves on accessible, open, and transparent government. It says it right in our Constitution. Recent years, there's a number of instances, some have been cited here today, where 91A requests have suffered from a lack of an inappropriate response, lack of timely manner, and of course, inappropriate denials. So we believe that House Bill 307 is a very simple solution that would encourage government municipalities and agencies to err on that side of presumption of disclosure. And for those reasons, we would urge the committee to support passage of this bill. And I would be happy to take any questions. I'll do my best to answer them.
Thank you very much, Mr. Maidman. Are there any questions from the committee?
Thank you very much.
Thank you. The chair will call Gilles Bissonnette.
Thank you, Madam Chair, members of the committee. Gilles Bissonnette, Legal Director with the ACLU of New Hampshire. First time testifying before this committee this session, so it's nice to be here. We are strongly in support of this legislation, and there really is a broad coalition supporting this. You have, really across the spectrum. You have AFP, the ACLU. Media outlets, Attorney Chuck Douglas, I think a broad coalition of individuals who think this bill is really critical in order for our public records law to be interpreted by government actors consistent with the presumption in favor of transparency that's embedded within the statute. And I think this bill would do just that. Mandatory fee shifting, which allows requesters to prevail in public records lawsuits to recover attorney fees and costs, is critical to ensure that the public's right of access is properly enforced. So currently, a person who goes to court and prevails would only obtain attorney's fees if they could show that the agency knew or should have known that the conduct engaged in was a violation of the chapter. And so as a result of this high standard, frankly, it is infrequent where a government actor that violates the right to know law, that a court has found has violated the right to know law, is required to pay attorney's fees. It is very rare. And I'll talk about the one case that I think is an outlier to that out of Nashua that was referenced in earlier testimony. Here, though, under this bill with mandatory fee shifting, when a requester successfully goes to court, this bill recognizes that the requester has actually brought a lawsuit that confers a societal good, right? These are the public's records. They're not the government's records. They are the public's records. And this bill recognizes that because when a person goes to court and prevails, that person may not have only advanced the law in favor of transparency, but has obtained tangible documents that should have at the outset belong to the people and been given to the people. And so what this bill does is recognize that public benefit that a successful requester obtains on behalf of the public. But the regime that we have now, where you don't have mandatory fee shifting, the result of the calculus is that people will not go to court, when they in fact may even prevail in court, because it is tremendously expensive. They have to hire an attorney, $280 filing fee, go through this whole entire process. And when they know that it is possible that they wouldn't necessarily obtain fees if they're successful, you have a lot of, I would submit, in all likelihood, successful claims that are simply just not brought. The flip side of that is that there are generally lower stakes for government actors when they decide that we're just not going to give you something. Because you have to go to court, you have to force the member of the public to hire a lawyer in most instances. And if they lose, well, you know, they produce the documents and generally they don't have to pay fees in the process. What this bill does in mandating attorney's fees is it forces a government actor, when they get that request on the front end, to know, gosh, there's risk here. If I say no, I may have to pay fees. So if there is a gray area, or if the law is clear, they are more likely to produce that information. That is a good thing at the end of the day, because that is what Chapter 91A is about, the underlying presumption in favor of disclosure. The law already tips the balance. It should not be for a government actor to receive a public right to know request, gosh, you know, there's a colorable basis to withhold this. I'm just going to withhold it. That should not be the thought process. The thought process should be, if there is gray area, that they should produce it at the end of the day. Because again, these are the public's documents. They are not the documents that belong to municipalities and government entities. What this law also does, I want to be very clear, is reinstate the law as it used to exist in New Hampshire for about a roughly 10-year time period. In the 1970s. And this was the law that this reinstates things to be was actually put in place back in 1973 when our right to know law was at its inception. And the language is modeled as closely as possible to that version of the law. After that mandatory fee shifting was put in the law, it was later removed, but when it was put in the law, the Supreme Court explained its importance. And to me, this really crystallizes why this bill is necessary. The provision for the award of attorney's fees is critical to securing the rights guaranteed by the statute. Without this provision, the statute would often be a dead letter, for the cost of enforcing compliance would generally exceed the value of the benefit gained. In some cases, the plaintiff may gain a financial benefit by the invalidation of government action taken in violation of the statute, but it will frequently be impossible to place a monetary value on the interests protected by the right to know law. The attorney fee provision was enacted so that the public's right to know would not depend on the abilities of individuals to finance litigation. Now, unfortunately, in 1986, that was changed. But that, I think, is why this is so critical, to get back to the way things were. What have we learned in the last 30 years since the changing of the attorney fees provision to what it is now, the new or should have known standard? I think we've seen a failure in the last 30 years. I think we have not always, but often seen government entities act with the notion that the law presumes secrecy, not transparency. And folks say, well, gosh, you know, there's so many court decisions on the right to law. You know why there's so many court decisions? Because government actors say, no, I'm not going to give it to you. And they force people to go to court, and courts have to, you know, issue rulings. And that is what we're trying to avoid. This is going to prevent litigation in the long run, because government entities, I think, are going to be more likely to produce information. But what have we seen in the past 30 years? I'm litigating a case right now with the Attorney General's office, where the Attorney General's office is withholding sustained misconduct from a police officer who the state police terminated. And they're saying, nope, we're not going to give it to you. Go to court. So I have to go to court. And this isn't about the ACLU. This is about people who are pro se, who have less resources. When they make requests, they should get timely access, just like any organization. And I think this bill, if passed, would help it. The city of Keene talked about the Salcetti case earlier today. The Salcettis had to go into the Superior Court, then to the Supreme Court, where the law was changed, and then they had to go back to the Superior Court once more to get access to summaries concerning complaints with respect to law enforcement. They shouldn't have had to go back to the Superior Court to litigate this case, but the information wasn't released. They had to go to court. So I think for all of those reasons, I think we really need to, I think this would be such a positive development under 91A. But this isn't just about police, and I want to be very clear. The Concord School District issued a report concerning an investigation into a teacher that engaged in very egregious activity. What was the initial reaction of the city there? We're not going to let, the families aren't going to get access to the report. That is the mindset that I think we need to change in New Hampshire, and I think this would go a long way. And ultimately, that was released. It required litigation and some changes in the law. But I think, I want to be very clear, this isn't just about police. This is about the broader concept of transparency and accountability. Now, I do want to just respond very briefly, because I know I've gone on and on, just to some of the things I've heard from some of the opponents of this bill. There are gray areas in the law. Gosh, why should municipalities have to pay if there's gray areas? Again, it goes to the point that I was making before, that this litigation, if successful, and this would only be triggered if it was successful, confers a public good. And if there is a gray area, I would submit that in those instances, that is precisely when there should be production, consistent with the law's presumption in favor of transparency. The recent New Hampshire Supreme Court case out of Nashua, where actually it's one of the rare cases where attorney fees were granted. Very much an outlier. I don't get attorney fees when I prevail. That's fine. Again, this isn't about the ACLU. It's about pro se and other individuals that don't have my resources. But this type of law, if passed, would actually deter the behavior of that city, which again reflectively decided not to produce information communications during a 2-month time frame between two individuals. That is the type of behavior that I think this would deter. So with that, I'll conclude my testimony. I want to thank the committee's time. I know I've gone on and on this, but I think this would be, of all the changes that could be made, probably the single most powerful change that could be made to 91A in support of transparency. Thank you.
Thank you very much for your testimony, Mr. Bissonnette. Are there any questions of Senator Whitley?
Thank you, Madam Chair, and thank you for taking my question. So I'm wondering if you know in other states on their right to know transparency statutes, whether it's common for states to have an associated attorney's fees attached to that.
There is, and the language does change state by state. The last page of my testimony, I do flag some states that have mandatory fee shifting like this proposal, which includes California, New Jersey, North Carolina. There is fee shifting also in the Federal Freedom of Information Act. It uses the term may instead of shall. That's in one way in which the federal FOIA law is not as strong as this bill. There is another way I want to flag in which this bill is not as strong as federal FOIA. In fact, under the federal FOIA statute, you could get attorney's fees even in the absence of a final judgment, where you could prove that the litigation caused a change in the agency's action. That is not the case here. This is in that respect more modest than the federal FOIA provision, because this only allows for attorney's fees if you get a final judgment. So you can envision a scenario, in fact, where a person litigates a case for 3 years and then, on the eve of a Supreme Court argument, the city decides to produce the information. You would not get entitled attorney's fees under this. I think I would like to see that, but, I think in the interest of being a little bit more modest there, that's not what the bill does. You have to obtain a final judgment. And I think with respect to Attorney Kennedy's point, if a plaintiff or a petitioner wins on 10% of a case, are they going to get attorney's fees on all 100%? I don't think that's the case. I think, you could get attorney's fees with respect to the time spent on the judgment that you secured, and not say the other portions of a case in which a judgment wasn't obtained.
Thank you.
Are there any further questions? Okay, seeing none, thank you very much.
Thank you,
Mr.
Madam Chair.
Matthew, if I can make a request for the committee, in the ACLU testimony, the second footnote, there's a reference to an article by Hooper and Davis, A Tiger with No Teeth, the case for fee shifting in state public records law. If you can get the committee a copy of that article, that would be terrific. Thank you. Okay, next we're going to call Natch Grace. Do you have a comment?
No, I said he could probably ask you directly.
Oh, okay. Natch Gray.
Thank you, Madam Chair. Nate Grace for the Municipal Association. We oppose this bill. I would, if you're giving the research person assignments, I would suggest that perhaps looking into the prior language of the statute might be helpful. It seems that some commentators have forgotten 1977 and the changes that were made then. You may find that enlightening. I also want to address something that Senator Whitley mentioned very early on here, a question she had. I agree completely that the policy set by the legislature, what this bill really does is it addresses what happens when it's unclear what that policy is. And so the issue for us is that when the government makes a reasoned judgment about what it should do based on the language of the policy set by the legislature, and it turns out that that's wrong, according to the people in the black robes, then the government's in charge of paying for that. Now, that's not saying that when someone at the government does something bad, that they're not already charged with paying for that, because they are. We saw that in Nashua. We saw the Supreme Court make that decision. And we have that pretty clearly in the statute now, which is, if they make a purposeful violation of this chapter, purposeful, willful, knowing, the same sort of concepts here. Someone does something wrong they knew was wrong. The government is in charge of paying for that. That already exists. And that's completely reasonable as a policy. We disagree with the policy that where the government is doing its best to comply with what the legislature wants them to do, and it doesn't exactly know what it's supposed to do, and it makes a policy that is, have you heard from other attorneys who have testified today, is recognized as reasonable by the courts, that the government should still have to pay for the costs of that litigation. It's more reasonable for us to flag that, or the courts to flag that, to come back to the legislature and ask for clarification and say, what is this policy supposed to be, so we can comply with it in the future? Or if the legislature is satisfied with the way in which the courts have interpreted it, that's what we go with in the future. So I don't have much more to add than that. I just wanted to add that to the record. Thank you.
Thank you very much, Mr. Gray. Is there a question from the committee? Seeing none, thank you.
Thank you.
The chair will call Catherine, is it Coco?
Good afternoon. My honorable members of the Judiciary Committee, my name is Catherine Coco. Almost exactly 1 year ago, I had the experience of testifying before you regarding changes proposed by my local state senator, and today I appear related to Right to Know. Today, I appear before you as president of Right to Know New Hampshire, a citizen-based organization that provides advocacy, education, and assistance to those who are seeking public information and increased transparency in government operations. Right to Know New Hampshire enthusiastically supports HB 307, which sets a more realistic standard for awarding attorney's fees when right to know cases are won by the requester. Based on the experience of our membership, the general public who seeks our help, and the attorneys with whom we interact, an award of attorney's fees is incredibly rare, and I think that's evidenced by the citation of the Nashua case that has come up a couple of times today. Right to Know New Hampshire has tried to gather what it could from available court records to be able to provide some data on that, but there is very limited ability to do so. So I apologize for not having hard numbers for you, but that is what we know from our experience. Not only is such an award rare, but in most cases, municipalities and state agencies typically outlawyer and outspend the average citizen when there's a contested outcome in a right to know case. The spending power and the knowledge base of state and local governments edge out that less powerful citizen, forcing them into the position of deciding whether or not they want to pursue an enforcement action that may lead to financial loss, even if they win. And even if they are able to do so, a citizen who makes rational economic decisions is unlikely to invest in an action that does not confer a personal benefit. The public good rarely outweighs the personal pocketbook. The playing field needs to be evened out so that the average citizen has a shot at coming out, if not whole, at least partially compensated for the public good that they are fighting for. Otherwise, they are further disincentivized to raise the issue at all. If our current law didn't rely on private action for enforcement, perhaps this strategy would not be necessary, but it does. I believe that reliance on private action is one reason that New Hampshire was ranked 34th in the nation and, as cited by a previous speaker, received a D- in public integrity in 2015 from the Center for Public Integrity. In the category of public access to information, New Hampshire received an F and ranked 49th. The report stated that the bar for recovering attorney's fees and other costs is dauntingly high. One related driver of that F score was that in practice, the entities to monitor the application of access to information laws independently initiates investigations and imposes penalties on offenders. That's the rating that they look at. Is there somebody who's independently doing this to make sure it's being enforced correctly? And the score that New Hampshire was given was a 0. In helping to create the Right to Know Ombudsman's Office as an alternative, the state has tacitly acknowledged the financial deterrent that prevents citizens from bringing their right to know issues to court. But even the creation of that office would not change the scored factor that I just mentioned, because the investigations still have to be instigated by private action, and existing penalties for violations, if they are found, are extremely limited. HB 307 would make it more feasible for those who do find themselves in court to consider pursuing their right to know enforcement actions. Since those actions take the place of independent monitoring in New Hampshire, they are contributing to the public good and a healthy discourse around implementation and enforcement of 91A. I've heard the argument that public bodies do not want to have to pay the costs associated with clarifying gray areas. Unfortunately, the majority of the time, this works to the advantage of the public body. As long as those gray areas exist, the uncertainty they create is and will be exploited to the benefit of the more powerful public body. Sometimes the only way to gain clarity on those gray areas is to bring a challenge to the system. That judicial clarification that results benefits the general public. Sometimes, even when the right to know case is lost, the clarification that is found in the case law still benefits the general public. Given the extremely high upfront costs associated with attorney's fees, this legislation is unlikely to precipitate frivolous action. What it will do is improve the chances that New Hampshire citizens will be able to fulfill the role that is assigned to them as independent enforcers of New Hampshire's right to know law, and encourage them to pursue cases where their position is at least obviously or very likely to result in a winning case and change the behavior of the public body. And I'd like to respond to a couple of comments that I've heard in the testimony today. I would emphasize again that this bill reinstates previous language. Some of the issues and concerns that I've heard about potential concerns, theoretical concerns, and complicated cases, I would make the point that the majority of cases that come up related to right to know are not those incredibly complicated situations that need to be teased out and result in an evolution of the law. They are fairly straightforward requests for documents and lack of response. And we see that in the requests that we get through Right to Know New Hampshire. We actually keep a spreadsheet of all of the types of inquiries that we get and are able to tally and classify those. And the kinds of situations that make their way to the Supreme Court are the kinds of things that need clarification, but they are not the majority. I would also be interested in learning, based on the previous language, we're talking about returning to prior language in the law. There seems to be a lot of concern about what would happen moving forward. It seems like we had this situation previously. We have some experience with this previous language already. No one has raised a concrete example of why it was problematic. I haven't heard that today. I would also point out that a lot of the opposition that has been heard today from attorneys has come from large New Hampshire cities who have processes and have support staff in place, and that most of the smaller communities in New Hampshire do not put the same or equatable level of consideration and energy into making these determinations. I think it's very common for municipalities in particular to look at 91A and try to determine what area of the law this particular request falls into and where they can possibly find an exemption. And that is probably the most common practice. It may not be something that a large city like a Nashua or a Keene does, but it is absolutely what we see from the smaller towns. And I'm not talking towns of 3,000, I'm talking anybody less than a city. And I think that covers most of my testimony for today on behalf of Right to Know. Thank you for hearing me.
Thank you very much for your testimony. Are there any questions from the committee?
Thank you.
Seeing none, thank you. Okay, seeing that everyone who has signed up to speak has spoken, are there, you are? Yes, you did sign up. You signed up in support, but you did not check the box to say that you were speaking. Please have a seat. Well, we are really behind on our last bill, so we've had a lot of testimony. We appreciate it if you could give us information that we haven't heard before.
Okay, thank you very much. Lori Ortolano Nashua. I'm a member of Right to Know New Hampshire as well, and I'm here as a citizen and a member of that group. I'd like to address a couple of the questions that were raised by Senator Carson on the ombudsman issue not being addressed. I think it's a good point, but I think that office is, first of all, a new office in its inception. I think that there are cases that involve right to know issues that litigants would prefer to take into a court or before a judge. And I think there might be individuals that believe that that their municipality wouldn't accept the ruling of an ombudsman anyway and would bring it before the court. I believe that would happen to me in Nashua, and I would end up before the court. And you have that right with the ombudsman bill not to accept the ruling of the ombudsman and move it forward and advance it to the court. So, and I also think on some of the issues that are more complex, I was a champion of that ombudsman bill. I really backed it strongly, and I want to see that office successful. But I won't take Nashua cases in there because I think the city's very difficult. And I don't want to throw garbage. I want to bring a dumpster fire to Tom Kerr as he's trying to set his office up. I have cases that are in the Nashua court now, and I'm keeping them in the Nashua court. And I want that office to be successful, and I don't want them to look at my stuff. So, you know, I think I wish the best of that office. On Right to Know New Hampshire, I can see a lot of questions and case matters that come to us that are what I think are pretty simple things. I can't get minutes. I can't get a response to something really simple that I think are perfect. For $25, send that before the ombudsman and see if you can get your records. I also find it really interesting that when I've taken constitutional classes, it's always pointed out that New Hampshire has this constitutional language that covers right to know. And we also have 91A, but we have this extra language that other states don't have. So we're in a power position. Well, why do we rate with a D and an F all the time? If we have this extra, arrow in our quiver, what's happening to us here that makes it so difficult for us to get records? And, I think going back to what we had is really important. And I think that, a statement was made by you, Senator, on what do you do with these people who put in right to know requests over and over and over again and burden their cities? Legitimate question. But I think that's, I think you deal with that. What do you do? I mean, I think that can be addressed really with the individual if the information is public and is sitting there and it's on the website and they're not using it and they keep writing and taking stuff that's readily available. I'd like to think that's a solvable case, or you can write them a letter. And if they're not, you got to go to court on that. But I can tell you, I don't see cases like that. But in my city, I think my city leaders would say, this is a lady, gazillion times she hits us and she does all these terrible things. Well, the information I go after isn't posted on the website, number one. Number two, our city recognizes or believes that if you ask a question, it's a right to know request. It gets docketed. And it gets docketed with a formal letter sent by a right to know administrator and sent to the legal office. And usually it says under RSA 91A, we're not required to answer questions. And I had a very active citizen send me a response. She wrote to the clerk's office and said, when are the new redistricting maps going to be up? Simple question a citizen would ask. And she wrote to me and said, what the heck is this? It was a letter back that said, under RSA 91A, we're not required to answer your questions. And as such, we're not going to provide an answer, but we're working on it. And it was docketed and sent to the legal office. She said to me, what happened to just asking when a map's going to be up? I had a lady just last week who wrote to the Board of Aldermen a position on how she felt about a Superfund site being developed in Nashua. It was just a letter. It came back to her with a response from the right to know attorney, denied that they weren't going to answer questions under RSA 91A. There wasn't a question mark in her letter, and it was docketed and put in a website. That's out of control. That's just ridiculous. And so what do we do with a city that's gone off the tracks like that? And this 3-2 case that, Attorney Lehman took for Laura Calhoun, terrific. I'm happy it was won. But I recognize what a 3-2 vote is. I'm going in, the city's appealing attorney's fees that Attorney Temple awarded to me, and they're fighting not to pay. I may be the 3-2 on the wrong side. I don't feel confident at all that I'm going to win. But I can tell you my right to know case on assessing records cost me almost $250,000 to bring before the court on assessing records. And I really think the fault of everything that went on here was the city of Nashua and how they handled it. And it's taken me several years to come around to see how we got played. And you know, it's maddening. And when you go to your city and they say to you, you try to get records, and they look at you and say, sue us. Literally, officials say, sue us. That's a terrible thing to hear. I don't want to sue them. And now I operate pro se. It's the last thing that was never on my bucket list. I don't want to be a pro se lawyer whipping around trying to defend myself. I just want my records. So I think this will help bad actors who are not behaving correctly. And I think somehow we've got to get this back to, there's so many citizens who are not putting in requests or not fighting records they're being told no to because they can't. One, you can't find lawyers to represent this stuff. They don't make any money doing this. Nobody is dying to take a right to know case. They're not dying for that work. And so I have citizens that constantly write to me and say, keep going. You know, if you can get records, then maybe I can get records. It's very sad to see that. And I think more general citizens should have open records. And because I had the pot of money at the beginning and I've laid down about $400,000 into right to know, I can't keep doing that though. You know, I'm not doing that. And when the city took every win I had, 3 victories, 2 pro se in court, appealed them all to the Supreme Court. When I looked and said, okay, let me I can't go to the Supreme Court by myself. I have no skill level for that. When I went to get the lawyers to help me, it was $200,000 for representation to take those 3 cases up. So guess what? I'm pro se. And, you know, I might not win. I don't have the talent base. But I just can't do that. So we're being killed on fees in Nashua, I'll tell you. And I don't know how to, it's a dumpster fire down there. And I'd love to see that change. And I think the city would smarten up if they knew they were going to get hit with fees a lot more. I do. Thank you for your time.
Thank you. For your testimony, are there any questions? Okay, thank you. All right, are there any other member of the public that would like to speak to House Bill 307? Okay, seeing none, we're going to close the public hearing. Oh, she's gone. Okay.
We're back in session. Can we take excuse me? Excuse me? Excuse me? Thank you. We will open the hearing on HB 321 and recognize the sponsor, Representative Yokella.
Thank you, Senator. Thank you for hearing my testimony today. I am here, for the record, Representative Joshua Keller from Fremont, Brentwood, and Danville. I am introducing HB 321 relative to minutes and non-public sessions under the right to know law. I feel like the last bill was a good kind of preamble to this, and I was kind of wanted to read a sentence from the preamble of the 91A. The purpose of this chapter is to ensure both the greatest possible public access to the actions and discussions and records of all bodies and their accountability to the people. So I definitely I think that this bill before you today will help ensure that the greatest possible access is achieved. And I think also that we heard in the last testimony things like 91A is not that simple, it's not black and white, that we need to clarify the law, that's difficult to interpret, ambiguous, all these languages coming from 91A. And this bill is the point of this bill is to hope to do some of that clarification. Specifically, the part of the law that I am trying to clarify is within the non-public meeting minutes, and a subset of those. There are certain topics which can be found to be able to be kept from the public. Once you go into non-public, you have these meeting minutes. Anyone subject to 91A, or actually, it's not everyone is able. Meeting minutes of non-public sessions shall be publicly disclosed unless the public body makes a finding of one of three things. It's going to harm reputation, it's going to make the action ineffective, or it has essentially to do with emergency and terrorism, kind of like prevention stuff. If you make one of those three determinations, then you can keep the minutes from that non-public session from the public. And there is a phrase inside of 91A that says, in reference to those three topics, in the event of such circumstances, information may be withheld until in the opinion of the majority of the members, the aforesaid circumstances no longer apply. And that assumes that the members, or kind of implies that the members are going to do this kind of regular review of these minutes that are kept from the public to determine whether or not the circumstances no longer apply. But in practice, it is rare, if ever, occurring. The Municipal Association recommends to municipalities that they do it annually, but it's not really spelled out in law. And what happens if you don't? If you never review them, is that giving you, as I stated in the beginning, the greatest possible access to those public records, if you're not actually ever reviewing them for those circumstances? And so what this bill is hoping to do is to kind of put some guardrails and say that the state has a policy of you can have a procedure and you can have it every year, you could have it every 2 years, every 5 years. That's all reasonable. But the outside limit is 10 years. Every decade you need to review these things, because if you're not doing that, then it's not really giving that greatest possible transparency that we're trying to achieve in New Hampshire. And so what this is saying in this statute is just, or this proposed law, is that you can have a policy, and the policy could be anywhere between 1 and 10 years. If you don't have a policy, 10 years is your policy. And if you don't review those minutes, those minutes every 10 years, then they're going to be automatically unsealed and open to the public to ensure that greatest possible public access. And so this does not require each individual meeting minutes to be sealed separately. You could make one motion once a year saying, I'm going to reseal these minutes. I think if you did not actually review the minutes and you just repetitively sealed the minutes, I think that that would show in your public meeting minutes and you would be held accountable by the voters. And so I think that this isn't, a it's not going to solve the problem, but it may bring some transparency for people that are trying to keep things secret, even though they should be reviewed and determined to be should be accessible to the public. So I'm happy. I worked on this language over this last summer with both Right to Know and Municipal Association to kind of make sure that, obviously Right to Know would like to have a much shorter time frame, and Municipal Association would prefer a longer time frame. And I came to get them to kind of agree that 10 years is a good starting place as far as this. So I believe that it has, there was no opposition in the House and it passed on consent. So hopefully it will get a favorable recommendation out of the Senate. Thank you for your time.
Thank you very much for your testimony this afternoon, Representative. Are there any questions from the committee? Seeing none, thank you, and thank you for waiting. We did run over a little bit with the other public hearing. Okay, the chair will call Douglas Osterhout and Shane Goulet.
Actually, I'm not ready to, so I like to be on this side of the table, unless Lindsay Courtney's here.
Good afternoon, Shane Goulet, attorney with the Office of Professional Licensure and Certification.
Good afternoon, Douglas Osterhout, General Counsel for the Office of Professional Licensure and Certification. Thank you, Madam Chair, for having us here this afternoon and letting us speak. We're going to try and be real brief because I know it's late in the day and we're all tired. We don't take a position on this bill at OPLC, but we do have a few concerns. And I just want to run real quick some of the reasons, because we oversee at OPLC 55 boards that are under our purview. We have public session, we have non-public session. 3 of the most common reasons we go into non-public session are under 91A32, letter C, matters which would harm the reputation of the individual, if spoken about in public. Typical, this comes in the form of license applications where somebody may have a criminal background check and the board reviews that application in non-public. Consideration of confidential information, there's more language to that. Information exempt from public disclosure under RSA 91A5. A lot of the times we see these in the forms of complaint deliberation. A complaint comes to OPLC, we investigate, we bring that before the board. The board makes those deliberations whether or not to proceed with an adjudicative process in non-public to protect the reputation of the individual. If they decide to go the disciplinary route, the information may become public, but at that point it's still confidential. And then consideration of legal advice provided by legal counsel. As the senator is aware, we do try to provide an attorney at every board meeting as much as we can. So I think our concern is that if the default is to make, if somewhere down the road, 10 years from now, 20 years from now, one of these boards fails to address some non-public minutes, and we're in a situation where they just haven't got to it for whatever reason, lack of quorum, the default is to make those records public. And that's our main concern, is that the default, I think we've got the competing interest of protecting the public, but it seems like the fallout would impact the very individuals that 91A32 was meant to protect, the reason we went into non-public in the first place. And we just thought we'd bring that to the committee's attention, that is a concern of ours. I'm trying to think if there's anything else. I think that might be it.
Yeah. Just briefly, I sit with the boards weekly. I'm board counsel for many of the boards over at OPLC. And just from a board perspective, and to be clear, I'm not testifying on behalf of any particular board, but just from my experience sitting with the boards, there's certain boards that have specific statutory prescriptions with their own statute that illustrates what is to be considered non-public and public information too. So this proposal legally poses a question as to what, if any, conflicts might arise as it relates to that. The other issue that potentially comes up as it relates to this is who is in the best position to make the determination of what is non-public and what is public at the time that that's made. Now, anybody who's within a public session can object to a board moving into a non-public session as it relates to, and the board would have to take a vote on that particular position at that point in time. There are also points in time where discussions can occur in non-public, and the board would not seal that particular section of the minutes. And that determination is made by a board at that particular time who is sitting there reviewing all the information, not just the minutes. I have nothing further, but available for questions.
Thank you, gentlemen, for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you both very much.
Thank you very much.
Thank you.
Okay, next, we're going to call Natch Grace. Natch Grace.
Thank you, Madam Chair. H. Grace for the Municipal Association. We support this bill, and we thank the sponsor for reaching out to us, working with us in a diverse coalition to come to an agreement about how to resolve this gray area of the law. As you've heard, there are 3 reasons for a board to seal minutes. Essentially, this bill would require them to follow our best practices, which is to adopt a procedure to review those sealed minutes. If they don't do so, it provides for a statutory alternative that they would follow after a 10-year period. We're satisfied with that, and we believe that's a good resolution, and we're happy to support this bill. I'm happy to take any questions you may have.
Thank you very much for your testimony. Any questions from the committee?
Yes.
Senator Chandley.
Thank you. Thank you for taking this question. I was interested in what the folks from OPLC said, and it made me think about the transition that occurs on boards regularly. How do you ever hear from municipalities that it is difficult for them to make the determination as to whether something should be unsealed because they don't have enough information?
So we do hear frequently from municipalities that have board turnover that there are challenges in assessing why minutes were previously sealed, whether they have the authority to go back. As they're acting as the board, much as the legislature acts on its former policies and changes those, they have that authority. What the right to know law provides is that minutes can only remain sealed for as long as there's a reason for them to remain sealed. So logically, that reason has to be captured in the minutes to justify that sealing, and that would be in the sealed portion of the minutes. So any board looking back should be able to ascertain why did we seal those. If they have a good reason and that reason still exists, they can keep them sealed under this bill. If there's no good reason or they can't figure out why, then it would become public, which is fair because the right to know law is supposed to open up governmental records to citizens.
Thank you very much, and thank you, Madam Chair.
Thank you.
Thank you very much for your testimony this afternoon.
Thank you.
The chair will call Tom Mullins.
All right, thank you again, Madam Chair and members of the committee. Just so you all understand, we don't just show up here to oppose stuff. We are in favor of this bill. I think back to the last comment, it really is important for the legislature to help us clarify what the policy is and what the procedures are under the statute. I like to tell people that the statute is sort of long on substance and short on procedure, so this is good. But what we would like to suggest is, and unfortunately I didn't have an opportunity to talk to the Municipal Association previously, it would be good if we could authorize in the bill an administrative release, or at least to allow the public body to, in its procedure, authorize the administrative release of non-public records. I know, at least in our city, and in talking to our city clerk, because city councils meet, ours meets every 2 weeks. When we have a lot of activity going on in the city, we tend to generate a fair number of non-public minutes with land purchases, sales, and that sort of thing. If we could authorize an administrative release for the clerk to review records, let's face it, 10-year-old records relating to the possibility of a land purchase or sale, probably nobody cares about. anymore. There may be litigation-related records from 10 years ago nobody really cares about anymore. This would, avoid the fact that we'd have to go to the public body and to the city council every time we wanted to release those records. It would just help us administratively to do that. My suggestion, if you were willing to consider something like that, would be in the very first sentence where it says regular review and vote. I would suggest after vote or to authorize the administrative release. And that way we would have that authority in the statute. As you know, we really can't act without the legislature giving us the authority to act. That would be our suggestion, but it's certainly up to the committee. At this point, I have no further comments or questions.
Great. Thank you very much for your testimony. Are there any questions?
Great. Thank you for your time.
Thank you. The chair will call Catherine Coco.
Right to Know New Hampshire strongly supports HB 321. We are in support of this bill along with NHMA, which took, I think, a lot of consensus building to get there, and it was a good thing. HB 321 requires a routine review process for minutes that are withheld. This occurs under a process that's colloquially referred to as sealing the minutes. And I know that we've talked about the language under 91A3, which says information may be held until, in the opinion of the majority of members, the aforesaid circumstances no longer apply. I think the reality is most municipalities aren't aware of that clause, and there is no specific language that outlines how they're supposed to implement it. So although 91A3 Roman numeral 3 implies the existence of a review process to decide whether or not circumstances apply, most towns do not have one. The fact that there is usually no historical record of non-public minutes that were sealed and the reasons why further complicates and informs citizens' ability to review potentially relevant materials to a current issue. A recent amendment to 91A now requires a listing of non-public minutes beginning in January of 2022 and has changed some of that process moving forward. This has been very much for the good. However, the historical record remains barred to public view, and for the most part, if minutes were sealed in 2015, 2005, or 1995, they remain sealed and without review. Until very recently, the practice in my hometown was to routinely seal all minutes of all non-public sessions. Minutes were sealed for the same reasons that the board went into non-public session, rather than for one of the 3 allowable reasons for sealing the minutes that's been discussed here today. And the town considered all sealed materials as sealed indefinitely unless the board took the proactive step of unsealing them, usually a result of public pressure. I personally had the experience of combing through several years' worth of past select board agendas to identify when non-public sessions that may be related to a particular current issue may have occurred. I then requested the minutes of those scheduled non-public sessions, and when I was told that certain minutes had been sealed in the past, I asked that they be reviewed for possible unsealing and was told by the administrative staff that after reviewing the minutes, there is no reason for the remaining ones to be unsealed. Clearly, they didn't have a process in place and it wasn't being handled through our elected board. At that time, my review request was not escalated to the board level for a further review process. After some back and forth with my community, I understand that as a result of the 2022 requirement to maintain that list of sealed minutes and non-public sessions, they now have a review process that is mapped out, but it applies primarily to minutes for the prior 12 months and does not address those grandfathered sets of minutes that are older. I haven't confirmed what that process looks like at this point. It just hasn't been an issue I've needed to dive into yet. I do not know what will happen when and if I begin asking for other materials that are older, but this bill helps to set a standard for that scenario. This bill does not create an undue burden on public bodies. It provides considerable leeway by allowing them to determine what their own process is going to be. It sets a minimum threshold of time for reviewing and confirming the status of sealed minutes moving forward. And it sets an exceptionally long period of time, 10 years, for retroactive review of the historical record before making it mandatory to release unreviewed materials. If the public body is concerned about information getting out that might be sensitive, it has an entire decade to review those minutes for those concerns. This bill also does not create a new requirement. Under 91A3, public bodies should routinely be reviewing those minutes, it simply hasn't been happening because the law does not specify requirements around that activity. This language essentially operationalizes something that's in existence and allows the public body to meet its responsibility to only withhold information for as long as necessary. The public itself then will gain access and informed insight into its own history. I would add, I heard something recently, and I'm not endorsing this writer or this book, but I thought it raised a very interesting point. I heard, I read an article and I heard an interview with a gentleman who, his name was Matthew Connolly. He wrote a book called The Declassification Engine, What History Reveals About America's Top Secrets. And part of his discussion and his point is that we have been classifying documents in exponentially increasing volumes over the years. And now we have a whole lot of classified documents and no real process for declassifying them on a routine basis and making them available. I thought the parallels to what happens at the federal level and what happens at the local level were very interesting because there's a lot more process and regulation and routine at the federal level than you see at the super local level. And I think we're losing information and we're not guaranteeing that people have access to something once it's no longer a concern. And it's essentially the same issue on a different scale in a different way. So.
Thank you very much for your testimony. Are there any questions from the committee? Seeing
Thank
none,
you.
thank you. Mr. Graves, would you come back up, please?
Senator.
We had a recommendation from Mr. Mullins from the city of Keene, and you had said that you had worked on this with Representative Yokela on line 3 of the bill, where it says the public body or agency may adopt a procedure to regularly review and vote or to authorize an administrative release.
We would support that.
You would support that, okay.
We want anything that makes it easier for the municipality to review those records and release them.
Okay.
We're for.
Okay, that's all I wanted to know. Does anybody have any questions?
Thank you.
Seeing none, thank you. Okay, are there any other member of the public who would like to speak to House Bill 321? Okay, seeing none, we will go ahead and close the public hearing. Thank you all for being here this afternoon. We appreciate your time. Thank you.